Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. For more information on any of the stories in this month's update, download our News In document using the link shown on your screen now. We have previously reported on the Payment Practices and Performance Regulations of 2017. These regulations oblige large businesses to report on their payment practices for most business-to-business contracts and are effective from financial years on or after the 6th of April of this year. Guidance on the regulations has now been published on the BEIS website. A recent High Court case re-examined whether a parent company can be liable for the acts of its subsidiary. This case related to pollution allegations about Shell's Nigerian subsidiary. The court determined in this case that the claimants were not entitled to bring a claim against Shell's parent company. A parent company will only be liable for the acts of its subsidiary where the damage was foreseeable. There is a relationship duty between the parent company and the claimants. It is fair and reasonable. The parent and subsidiary are effectively the same for the relevant business, and the parent had or ought to have had superior knowledge. High Street retailer Wilko has been fined over £2.2 million after pleading guilty to health and safety failings that left an employee paralysed. This prosecution follows the recent £5 million fine levied against Merlin Entertainments for the Alton Towers incident, and this demonstrates the increasing costs for health and safety offences under the new sentencing guidelines that were implemented last year. A former recruitment consultant has been prosecuted for emailing over 100 client contacts to her personal email account before moving to a new job at a rival recruitment company. The Information Commissioner's Office has now issued a warning that it is against the law to take clients' personal information when moving to a new company. A SAR can be used by an individual to oblige a business to release personal data that it holds about him or her. There are, however, exemptions to this obligation, and a recent case has confirmed that generally a business does not need to disclose personal data when it has been created for litigation or where it comprises of communications between the business and its lawyers for legal advice. Guidance is now available on the ACAS website concerning the gender pay gap reporting obligations for large businesses. The first gender pay gap reports in respect of April 2017 pay data will be due by the 4th of April 2018 and must be published for 3 years on the employer's website and a central government website. Employment tribunal decisions are now available online and searchable by name of employer and employee. For employers, this may be a useful source of information about job candidates, but it should be used with caution. If an employer has more information about a candidate, then inevitably there is more risk that a rejected candidate will claim that he or she was rejected for an unlawful reason, e.g. because of sexual orientation. If an employer intends to use tribunal data, then it should use it for all employees and ensure that it always carefully documents its lawful reasons for rejecting candidates. Key provisions of the Trade Union Act came into force on the 1st of March, including a 50% turnout requirement for all industrial action ballots, a requirement that 40% of those entitled to vote support industrial action in important public service ballots, new rules about information that must be included on the ballot paper, a summary of the issues and details of a planned industrial action, an extension of a notice period to be given to employers for industrial action from 1 week to 2 weeks, and the expiry of a mandate 6 months after the ballot, a requirement that union members opt in to political fund contributions subject to a transition period of 12 months and only in respect of new joiners. A voluntary code of practice has been agreed between the major search engines and the creative industries in February to make it harder for consumers to find pirated content. The IPO has been deliberately coy about the detail to avoid the ability of pirates to game the system. but we understand that it will involve search engines pushing pirated content down the search lists. In a recent case, a retailer provided free Wi-Fi, which was used to upload a song that infringed Sony's copyright. In CJEU proceedings, the retailer successfully argued that he was not liable and was merely an unwitting conduit. However, the CJEU determined that Sony still had the right to obligate the retailer to prevent any reoccurrence by, for example, making the Wi-Fi password protected and only supplying that password to those who had provided details of their identity. Following this case, it is important that providers of Wi-Fi do implement security controls, otherwise they may find themselves on the wrong side of expensive injunctions. Thank you for tuning in to this month's Commercial Bulletin. For more information on any of these stories, please contact Radius Law or my colleagues at LexisNexis. We'll be back in April with another update.